haven't started. It's Marquesa. Did you want me to just start now? Or?
Yes, please, Marquesa. Sorry, because my computer hung. Actually, it crashed. So I had to log back in. Okay.
Oh, no, yep, no worries.
Okay, go on, Marquesa, please.
Okay, sure. I'm just going to, sorry, I'm on the PowerPoint. Just trying to figure out, there's a button on the PowerPoint, did you say, to
So
upload?
what you need first to do is to open the PowerPoint slide.
Yep.
And once you've done that, there's a share screen function at the bottom of the Zoom screen.
Oh, okay.
Yeah, just click on that. And once you click on that, choose the PowerPoint slide that you've opened.
Share screen. Yep, got it. Okay. Okay, let's see. That should work. Are you able to see the PowerPoint?
Yep, I'm seeing it. Thank you.
Okay, terrific. Okay, great. So what we'll do is I've just had to adjust the audio as well. So, okay, we'll go straight into the issues in Syria. So Jasmine's given us a bit of a background as to the conflict. We'll just looking at the time here, so we'll try to keep this as quick as possible. So we're going to cover the issues of international human rights and humanitarian law, starting with the principle of distinction, specifically Rule 2 in relation to the distinction between civilian and military combat. So we're going to discuss international humanitarian law, international human rights law, the principle of distinction, the Geneva Convention, the Hague Convention, judicial and non-judicial enforcement of the law of war. And then we'll quickly turn on to the United Nations War Crimes Investigation and then the International Criminal Court. So we'll try to get through that in the 12 minutes that I have. So I'll try to be as quick as possible. So starting with the issue of the principle.
Marquesa, hang on.
Yeah.
I don't think you have 12 minutes. That was meant to be 12 minutes for the entire group. And we have about 7 minutes for the question and answer. Isn't that correct?
7 minutes? Sure. If I can probably do this in less than that anyway.
Okay, so if you could do it in 5 minutes, so we have enough time for feedback, for me to give feedback and then to ask questions as well.
Okay, sure.
Yeah, because the total allocated time, as I pointed out early on, was that each group will be given 12 minutes, wasn't it? To present the factual background, to do the presentation, and then about 7 minutes for the question and answer. Yeah, so I think if you're just about to use up the 12 minutes, so I'll give you an extra 5 minutes to cover the rest.
Okay, so I might just have to kind of brush over some of this, but okay, so let's just go very quickly to the really salient points here. Salient points being the principle of distinction. What are the legal principles of the law of war? What are the legal principles of international humanitarian law and human rights law? So we'll start off with the principle of distinction, which obviously distinguishes between civilians and armed combatants and sets forth the requirements for legal combat within war, and that is that the only legitimate object which states should endeavour to accomplish during war is to weaken the military forces of the enemy. I'm going to brush over the definitions of what a military objective is. You can sort of come back to this and give that a bit of a read, but suffice to say that it is not to be bombing civilians and hospitals. So moving on from that point, the central questions therefore is, has Syria committed a war crime? Has the Assad regime committed a war crime in targeting civilians? And if so,
We couldn't hear you, Marquesa. Can the others hear Marquesa? Or is it just me who can't hear her?
It's dropped out for me as well.
Marquesa, we can't hear you. Marquesa, we can't hear you.
I think she dropped out.
Ah,
Maybe it's her internet. Yeah, it says she's not in session. I tried to send her a private message rather.
okay, thank you. So just wait a bit for it to come back.
Can't hear you now, Manjo.
Sorry, I muted myself. Okay, so the group, the Justice for Syria group, has actually used up about 16 minutes so far out of the 20 minutes, and I'm aware of the time. So what I'd like to do, Jasmine, if it's all right, I'd like to hand over the presentation first to the next group, which is the treaty group, and then we'll get back to you, if that's okay. As soon as Marquesa is able to rejoin us.
Yep, that's fine.
Okay, thank you. So can I give the floor to the treaty group to begin its presentation?
My name is Peter, and I'm going to start with the introduction, followed by Tracy, and then followed by Annie. So I'm just going to bring up the screen. Yeah. Okay. Share screen. Share screen. Share the desktop here. Share screen. Okay. Okay. Can everybody see the screen here? Is that a yes?
Yes.
Yes.
I see it.
Okay. Thank you. Thank you. Okay. I presume the clock starts now, does it, Manjo? Yeah. Okay. Okay, folks. In Syria today, there is a humanitarian crisis which has evolved over the last 5 years. And the question we want to ask the group and the class is, who is responsible for this? Just a background on it. We have the Syrian Civil War, which started in 2011 following the Arab Spring or the Arab Uprising right across northern Africa. There were peaceful demonstrations originally in Syria, and as was rightly said in the first presentation, there were demonstrators. Assad came down very strongly against them and tortured and killed quite a number of civilian demonstrators. This turned into a group of armed military who defected from the government armed forces and started their own military to change the government. And at the same time, in around 2012, a year later when this began, we had ISIS and ISIL that moved into northern and eastern Syria. And so it was a really complicated mess that occurred in Syria. In 2014, the international coalition was led by USA. There was bombing of the IS targets in Syria. Then in 2015, Russia decided to launch bombing campaign against ISIL and those against the Assad regime. USA stated its opposition to Assad and made it clear that Assad had to go. But it held back and eventually basically let Russia take over the bombing, and it wasn't because of mutual consent. It was more of logistics and problems with working together. In November 2016, there was a really serious effect by Russia against the largest city in Syria, which is Aleppo. And during November, there was some more heavy bombing and civilian casualties. Just to recap, in 2011, the population of Syria was 23 million. That's just under what the population of Australia is. And since then, there's been more than 11 million people displaced and fled or have been killed in this war. As 400,000, more than 400,000 refugees have left Syria and ended up in neighbouring countries, including Europe. And Syria is close allies with Iran and Russia. Assad and his previous president, his father, they've had close ties with Russia. Russia's had a naval base on the Mediterranean for a long time, and so that's kept them in close contact or close relations. There's been international condemnation for the killing by Assad forces and the Russian military, so we've got a question on who is responsible, and the focus is on these two powers. And these events have raised several questions. Is Russia's military involvement in Syria legal under international law? That's a food for thought. And following a request by the Syrian government, Russia stepped in. The request was to help remove the foreign fighters and ISIS from Syria. There's some legal issues here, the validity of the invitation and the legitimacy of the inviting authority. There's been a lack of unanimous international consensus on the action for ceasing hostilities. So now I'm going to hand it over to Tracy for the next slide.
Tracy, are you the one speaking? I think you've muted yourself.
Oh, sorry, I'll start again. Did you hear the first bit? I'll start again.
Yeah.
Get back to the first slide then, Peter. Sorry, I'm talking away and not even hearing me. Okay, I'll start again. Is state immunity deserving for Assad? State immunity is the principle of customary international law where one sovereign state cannot be sued before the courts of another sovereign state without its consent. So a sovereign state is exempt from the jurisdiction of foreign national courts. Does Assad deserve this kind of immunity? Can a state official be subject to prosecution in a foreign domestic court for international crimes? Can personal immunity continue to apply even when prosecution is sought for international crimes? Next slide. It is commonly accepted that state officials are immune in certain circumstances from the jurisdiction of certain states. There is still uncertainty about how far those immunities remain applicable when an official is accused of committing international crimes. Do they remain applicable in criminal proceedings where an official is accused of committing a crime under international law? Under customary international law, the head of a state to a foreign state possesses such immunity from the jurisdiction of foreign states. It is argued that state immunity applies only in respect of sovereign acts and that international crimes can never be regarded as sovereign acts, and acts which amount to international crimes may never be regarded as official acts. When a state engages in acts which are contrary to the principles which form the norms of international law, that cannot be set aside as it waives any rights to immunity as a state has stepped out of the sphere of sovereignty. The principle of international law, which under certain circumstances protects the representatives of a state, cannot be applied to acts which are condemned as criminal by international law. Those who commit these acts cannot shelter themselves behind their official position in order to be free from punishment in the appropriate proceedings. Next slide. The involvement of the United Nations. The United Nations has actively been involved in the situation in Syria. As outlined in Chapter 1, Article 1, the purpose of the United Nations are to maintain international peace and security, take effective collective measures for the prevention and removal of threats to peace and for the suppression of acts of aggression or other breaches of the peace. Under Chapter 7, under the title, Action with Respect to Threats to the Peace, Breaches of the Peace and Acts of Aggression, under Article 39, the Security Council shall determine the existence of any threat to the peace, breach of the peace or act of aggression, and shall make recommendations or decide what measures shall be taken in accordance with Articles 41 and 42 to maintain and restore international peace and security. Next slide. So what is the legal basis for foreign military intervention? Syria is not a signatory on the Rome Convention. Therefore, it is outside the ICJ jurisdiction. The only way the ICC can achieve territorial jurisdiction in Syria is if the UN Security Council refers the situation to the country to the court. Demands for such a referral from the UN Security Council are as old as the conflict itself. Initially, there was little appetite to have the ICC involved. In 2014, following a failed round of peace talks, the United States threw its support behind a referral of Syria to the ICC, and only when it was perfectly clear that Russia would veto any such referral, which Moscow particularly did. The Security Council failed to adopt 2 draft resolutions on Syria, despite appeals for actions preventing impending catastrophe in Aleppo. There were 2 draft texts, one from France and Spain and the other from the Russian Federation, addressing the conflict in Syria. These failed to be adopted by the Security Council amid heated debate on content and urgent calls for humanitarian intervention for the besieged city of Aleppo. The French and Spanish texts that would have had the Council demand an immediate halt to all aerial bombardments and military flights over the site of Aleppo. The text would have also urged the immediate implementation of cessation of hostilities, as well as the immediate, safe and unhindered humanitarian access throughout the country, and demand the parties of conflict, in particular the Syrian authorities, fully implement all previous Council resolutions. Frustrated by this decision, France and US have called for war crime prosecutions over the ongoing assault in Aleppo. Such calls for legal action have been issued multiple times in recent years, including by the United States. Is the international community any closer to delivering justice today for the suffering in Syria? What are the prospects of accountability for war crimes in this ongoing and tragic civil war? I'll now hand over to Annie to continue our presentation.
Thank you, Tracy. So is Russia's military involvement in the Syrian Civil War legitimate under international laws? Article 2, Section 4 of the UN Charter states that all members shall refrain in their international relations from the threat of the use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. That is to say that the use of military force by one UN member state in or against another state is illegal under international law. However, this rule is subject to 3 exceptions. Military action in self-defense, military action authorized by the Security Council under Chapter 7 of the UN Charter, and military action based on the principle of intervention upon invitation. In September 2015, following a request from his Syrian counterpart, Russian President Vladimir Putin received authorization from the Federal Council, which is Russia's upper house of parliament, to launch airstrikes on Syrian soil to help contain the civil war, therefore invoking the international legal principle of use of force by intervention by invitation. The exception of intervention upon invitation is whereby a state might request other state or states to use military force within its territory. 2 legal conditions must be met in order to invoke the principle of intervention upon invitation. These are the validity of the invitation, and the legitimacy of the inviting authority. While Russia has not yet issued documentation outlining the request of the Syrian regime, the valid consent of the Syrian president is observable as there is coordination of military operations between pro-regime ground troops and Russia's air force. International Court of Justice addressed a similar situation during the case of Nicaragua versus United States of America in 1986. The plaintiff, Nicaragua, claimed that the United States of America violated the sovereignty of Nicaragua through a number of actions. In response, the United States of America upheld that it was acting under the principle of intervention by invitation, following the receipt of an invitation issued by the Nicaraguan opposition. The International Court of Justice stated then that the invitation to intervene in the sovereign affairs of a foreign state only possesses legal basis if the invitation in question is extended by the legitimate government of the state and not by the opposition. Similarly, it could be argued, since no authority exists that can enforce or interpret international law, that Russia's military intervention in the Syrian Civil War is legal, as the Syrian regime, which is the legitimate government of Syria, according to Russia, did issue an invitation for Russia's military intervention. Following this line of thought, it can also be argued that the states invoking the excuse of counterterrorism in order to be present on Syrian territory without the consent of Syrian regime, whether on the country's land, in its airspace or in its waters, are violating Syrian sovereignty. So is Russia failing to comply? According to Article 20 of the text of the Responsibility of States for Internationally Wrongful Acts of the International Law Commission, the principle of intervention upon invitation can only stand as a legal basis if no actions taken by the invited states constitute a violation of preemptive norms of international law, for example, committing war crimes. The principle then becomes nullified.
2 more minutes.
What was that? Sorry, Manjo?
2 more minutes.
Okay, I'm nearly done.
Okay.
Several organisations, including Amnesty International and Human Rights Watch, have demonstrated that Russia's actions in Syria, the launch of aerial strikes against hospitals, for example, constitute a violation of international human rights law. Should Russia be proven to have committed violations of international human rights law, its pretense of defaulting to the principle of intervention upon invitation would no longer have legal justification. This concludes our representation.
Thank you. Thank you. So what I do at the end of every presentation, hang on. Okay, so what I do at the end of the presentation is to provide feedback. Now, what I like about the presentation is that it's quite organized, and the group used images to really evoke emotions and to compel the viewer to really imagine the horror that's going on in Syria. So that is good. And I also like the fact that the presentation was quite comprehensive. You actually addressed a lot of the legal issues involved, not only about issues about the application of international humanitarian law. You also addressed the question about war crimes. You also addressed the question of state immunity, as well as the use of force and whether or not there was any legal basis for the intervention of Russia. So as far as the content of the presentation is concerned, I rated you quite highly at 23 out of 25. And I'll explain the reason why it's not really 25 in a short while. Well, the reason why you're not getting 25 is that it's overly comprehensive. And I flag to the group's attention that when you make your individual research essay, given the limited word count, you need to focus on one, at the most two, fundamental legal issues. You cannot cover all the legal issues. It's simply not possible. So it is really up to you, because it's an individual choice on what legal issue you're going to focus on. But some of you may focus on international humanitarian law, others might focus on the issue of war crimes, others on state immunity, and so on. But you cannot cover everything in the individual research essay. It's simply impossible. I also like the fact that you were using bullet points, and generally when bullet points were used, they were just used as prompts and as cues for the purpose of doing a presentation. So the presenters were actually reading off the screen, which is good. Because so that's a good way of doing the presentation. You don't load the screen with information from which you then read. So I saw that, and I also saw the group was quite organized. In relation, though, to the one by Peter, Peter, perhaps next time you need to really sum up what you're going to put on the screen, on the PowerPoint slides, because in most cases you were using full sentences. You should just be using phrases, because the problem if you use full sentences, for example, and you end up reading it, is that what would happen is what is known as information overload. There's so much to read on the screen while a person is listening to a presenter talking, and that is really difficult to do. It's called cognitive overload. You can't read effectively while you're listening. Okay, so in relation to the presentation, I scored the group 23 out of 25. I'll come up with the my score in relation to response in a short while after I ask a few questions. As far as the organization is concerned, I gave the group 25 out of 25. So the group so far has done really well. Okay, now again, in relation to the individual research essay, you have to limit your discussion to a few of the legal issues. Okay, so I'd like to begin by asking a few questions, or would anyone else in the class wish to ask questions first?
Oh, sorry, Manjo. It's Marquesa Margolin. I thought I'd just jump in. Sorry, my computer just turned off completely, like in the middle of that, which is super strange. Never happened to me.
It happened to me earlier as well.
That is so bizarre. And the lights went off in my place earlier today. So I'm just like, there are weird things going on. But anyway, sorry about that. So whenever you're ready, could be at the end. I can do like, or just.
I actually sent you a private message, Marquesa, saying that we will get back to you after the 3D group is done with this presentation. Okay. So we're going to get back to you.
Okay, thanks.
Okay, would there be questions from the class, for the group, before I start asking my questions? No? Okay. I'm curious, because the group asked whether or not Russia was legally involved in Syria, primarily because Russia is using force. The US is involved in Syria as well as I think as Australia, and they're using force as well. Why aren't we asking whether the United States and perhaps Australia might be committing a breach of international law by using force?
Because it appears Australia and America haven't been bombing as many civilians since the Russians stepped in. There seems to be a huge amount of civilians being killed in medical facilities and hospitals.
The question is the US using, and are the US and Australia using force in Syria or not?
Yes, they were using force in Syria, and the reason why they were, the coalition were aimed at, they were aimed at eradicating ISIS and ISIL that spread into Syria, and they made it clear to Syria that that's what their targets were, a terrorist organisation.
Thank you. Now, in that case, so that was very helpful, Peter. It provided the context of the involvement of the US there. The question is, if the US did that, are they potentially committing a breach of international law? And if so, what might that be?
There's an article I read where they were using that second exception of self-defense. And that was their legal right into Syria, was using self-defense against ISIL due to the terrorist attacks.
Okay. So even assuming they're using the so-called principle of self-defense, which we know is actually highly controversial, could they potentially be breaching international law by bombing, ISIS and ISIL in Syria?
Potentially they could be. That's possible, but I think
what international law principle are they breaking, potentially?
Operating inside a sovereign state without permission.
So they're breaching the territorial sovereignty of Syria. Okay, so that should have been addressed. I was thinking it's quite one-sided in focusing on, I'm pro-US, pro-Australia, obviously. But if we're looking at international law questions, you can't be judging the actions of Russia without considering the involvement of Australia and the US. Okay, so let's just move on. I'm happy about the fact that in one of the presentations, I can't remember who it was who said it, there was a reference to the Rome Statute and to the fact that possibly the Bashar al-Assad and the Syrian government might be committing war crimes. Now, there was a factual error, though, there in that statement, because the Rome Statute is actually the statute of the International Criminal Court of Justice. It is not the ICJ statute. So in other words, if Syria is not a signatory to the Rome Statute, what it simply means is that it hasn't subject itself to the jurisdiction of the International Criminal Court of Justice. It is not about the ICJ. Okay, so let's just clarify that. Now, having said that, how can Syria or Bashar al-Assad potentially be committing a war crime if it is not a signatory to the Rome Convention? Meaning it hasn't agreed to be bound to the jurisdiction, to be under the jurisdiction of the International Criminal Court of Justice.
Syria is a founding member of the United Nations, and I'm not sure what article it is, but they are bound by the Charter of the UN. And on top of that, they became a signatory to a number of treaties, one of which was human rights and the protection of, I've forgotten, without looking it up quickly, I'm sorry, I can't recall what it is.
Okay, but the question I asked was, if Syria is a signatory to the Rome Convention, which is actually the statute which created the International Criminal Court of Justice, how can Syria or Bashar al-Assad potentially be committing a war crime and be subject to the jurisdiction of the ICCJ if they're not a signatory to the Rome Statute?
Can we is this open discussion or?
Yeah, Maikasa, you could jump in.
Oh, no. If it's not for Mike, I'll leave it to them. I'll stay with it. I'm out of it.
If the UN Security Council refers it to the...
Sorry, who was that?
If the UN Security Council refers the situation in the country to the court?
To the ICCJ?
Yeah.
No, but my question was, how can Syria be be under the jurisdiction of the International Criminal Court of Justice if it is not a signatory to the Rome Statute, which created the International Criminal Court of Justice? And related to that question is, how can it be committing a war crime as defined by the Rome Statute if it is not a signatory? Because remember that under conventional international law, a state can only be bound by international law if it has given its consent. That's a conventional duty in general. In this particular case, especially if you're invoking the Rome Statute, which is an international convention, then only the parties to the convention can be bound by it. But as you pointed out earlier, Syria is not a signatory to the Rome Statute. So how can Syria now be bound by the Rome Statute, particularly in relation to the definition of war crimes, if it is not a signatory to the Rome Statute? That's my question. Or is there a way for Syria to potentially be committing a war crime and therefore be bound by international law, even outside of the Rome Statute?
What about a preemptory norms of international law?
Very good. That's actually correct. Because the Rome Statute is quite recent. It came out in the 1990s. And we remember that after World War II, we had the Nuremberg trials and the Tokyo trials, where the military officers of Nazi Germany and Imperial Japan were actually subjected to war crimes trials, and they were found guilty. So there are peremptory norms prohibiting war crimes. So the only issue there is that Bashar al-Assad may not potentially be, cannot be under the jurisdiction of the ICCJ, but it is possible for the International Court, if it ever gets to arrest Bashar al-Assad somehow, to create an international court to try him for war crimes, for committing a violation of peremptory norm of international law. Okay. Let's see. Yeah. Okay. So there's the other question I have is, and this relates to the international humanitarian law, because you had talked about torture, you had talked about the bombings on civilians. The basic question I have, and this is a question which I'll be asking the group Marquesa as well, is, does international humanitarian law apply to the conflict in Syria? And why, or why not? Because you had mentioned international humanitarian law, so I asked a question. Is international humanitarian law actually applicable to the conflict in Syria?
It is because according to customary international law, Rule 15, they have to do precautions in attack, and they're not allowed to target civilians or hospitals or medical facilities. And they've done that, so they're breaching customary international law rules.
The problem with customary international law in relation to that is that it focuses on armed conflict between states. Okay, now the armed conflict in Syria is not between states. It is the Syrian government versus rebels, local rebels, and it is the Syrian government versus ISIS and ISIL. So
it's become internationally involved from other countries, so it is an international problem. No?
If you look at the Geneva Conventions are clear that as far as the international armed conflict is concerned, it is limited solely to armed conflict between states. And there is a notion of non-international armed conflict. And if that occurs because the armed conflict is not between states, then the other Geneva Conventions actually do not apply. So for example, the Geneva Convention on the treatment of prisoners of war does not apply. So I think you need to address that. Just be careful. So I'm flagging to your attention now that your reference to international humanitarian law for now is quite superfluous. You need to address that because I'll discuss that more when I talk talk about that with a group of Marquesa. But you're on very shaky ground if you simply make the assumption that international humanitarian law can actually be applied to the conflict in Syria. That is too simplistic. Have a look at my notes this week because I discussed that. Okay, so because we were kind of running out of time, we needed to get back to the group of Marquesa. So as I said, I gave the group 25 out of 25 for organization, 23 for content, 23 for presentation, and for the response, I gave your group 20 out of 25. That would still be, that's a 91, so that's a high distinction. Well done. Thank you. That was very good. So I go back. I would like to give the floor now back to Marquesa to finish her presentation and then to field questions from the class.
Thanks, Manjo. Yeah, so I'll just go back to where I was on the PowerPoint. And also that's a very relevant point that I think should be explored further in relation to the application of international humanitarian law and its relevance as to what treaties and conventions actually have been accepted by Syria. Having said that, I would like to just point out that the way we've approached the assessment is on the basis that the United Nations Security Council obviously does have the jurisdiction to refer the matter to the ICC, notwithstanding the fact that the Syrian government is not a member of the Rome Statute. So that's the way I've approached the issue. But it's a very, very valid point, and I think that I'm glad that we had this discussion because I think it should be explored further, definitely in the take-home paper as well. So that's just obviously a very, very valid point that I just wanted to clarify there. So moving back onto the PowerPoint, I'll just sort of pick up where we left off. Sorry. Now I pressed the button that, oh, share screen, got it. Okay, great. Terrific. So are you able to see the PowerPoint?
Yep, we're seeing it.
Okay, wonderful. So just to go over I think Jasmine has already covered the background. So we know the parties that are associated with the conflict. It started with the peaceful protesters demonstrating the regime. There was a violent assault by the regime in response to that protest. Civilians then formed rebel forces. Al-Qaeda then seek to opportunistically...
Marquesa, can you wind this up in about 3 minutes?
In 3 minutes, yep.
Yeah, thank you.
3 minutes, okay. So that's the history of the conflict. the significance of war crimes comes down to the torture of prisoners of war, the use of chemical and biological weapons, which Syria did. There were two different treaties, one of which Syria signed but never ratified. The other one Syria is bound by. The issue of bombings hospitals as a strategy of war, whether or not that constitutes a war crime. Bombings of schools and children, obviously as a strategy of war, and civilian occupied territories. So just to go on to the issue of conventions, laws, and treaties on the issue. So obviously we have the issue of Hague Law, Geneva Law, the conventions. We'll briefly go through. So the Hague Convention and Regulations, Article 25 of the Principle of Distinction defines exactly what can and cannot be done in war. The attack or bombardment by whatever means of towns, villages, dwellings, or buildings which are undefended is prohibited under Hague law. The statute of the International Criminal Court, again, will go into further detail because obviously that has to be referred by United Nations Security Council. So that's a whole nother issue. But assuming that Security Council did refer it to the ICC, assuming that they did have the go-ahead to prosecute war crimes, then these provisions would come into play, which is that intentionally directing attacks against the civilian population, not taking direct part in hostilities is indeed a war crime. We covered the issue of Geneva law, that being relating specifically to the treatment of civilians, hospitals, the sick, the wounded, Article 3.2 of the Convention, which states the wounded and sick shall be collected and cared for, and impartial humanitarian bodies such as the International Committee of the Red Cross may offer its services. You go on to Section 27 of the Convention, which again discusses in seizures and bombardments, all necessary steps must be taken to spare buildings dedicated to religion, art, science, more relevantly, hospitals and places where the sick and wounded are collected. The issue of torture of prisoners of war, again, that goes to Article 13 of the Convention, which specifically states that prisoners of war must at all time be humanely treated. Any unlawful act or omission by the detaining power causing death or seriously endangering the health of a prisoner of war, again, is a war crime. Article 3 and Article 13 of the Convention and Protocol, in addition to the Geneva Protocol, I should say, specifically Article 11 discusses the issue of chemical and biological, bacteriological and biological warfare, and expressly prohibits the use during conflict. Obviously, these are all the relevant issues that we've covered in respect of humanitarian and human rights law. Now, we've limited our discussion on the use of force and whether or not these violations of the conventions and treaties constitute a war crime. We haven't discussed in detail whether or not it could be prosecuted by the ICC, whether or not it could be referred. Obviously, right now, that's a discussion that is, in fact, still ongoing with the United Nations Security Council. There has been discussion recently that it will be referred to the ICC, but we haven't gone into whether or not it could be prosecuted.
Can you wrap it up in a minute, Marquesa?
Yep. So, in essence, the primary issues as to what the war crimes would hypothetically be would be listed on this page, which is the torture of prisoners of war, the use of chemical and biological weapons, strategic bombing of hospitals, schools and children, and civilian occupied territories.
Okay. Thank you. Thank you. So thank you, Marquesa. And so I'm going to provide my feedback now. I'm happy with the organization of the presentation. So the key points were presented. In terms of I gave the group 23 out of 25. In terms of the organization, I felt it was quite organized, the way that the ideas were presented. The presentation itself, I gave 22 out of 25, mainly because there were some PowerPoint slides where there was just too much information that was there. But 22 out of 25 is quite high. I also acknowledge that images were used, which really enhanced the communication of key ideas of the presentation. I have issues, though, about the content, again, primarily because there seems to be an assumption that international humanitarian law is applicable. And this, in fact, is a basic question that needs to be answered.
No, it isn't applicable.
I'm
What,
sorry?
what we're saying is international humanitarian law can only be enforced if referred by the United Nations Security Council, meaning not with respect to some issues in respect to the agreements, the Geneva Convention on chemical and biological weapons, but we're working on the assumption that war crimes could indeed be prosecuted by the ICC.
Wait, are you saying that war crimes and international humanitarian law are the same?
No, I'm saying the prosecution of international humanitarian law violations, which are indeed war crimes, we're working on the assumption that they will in fact be prosecuted. So that's an assumption that we've made based on the fact that we assume that the United Nations Security Council will refer it to the ICC.
Just be careful with that statement, because the mere fact that a state may be violating international humanitarian law doesn't mean that it is committing a war crime. Those are two distinct things. Now, in relation to your statement that international humanitarian law is potentially applicable if it is referred by the Security Council to the ICCJ, is actually incorrect. The international humanitarian law is applicable if the conditions are there. So, for example, in relation to an international armed conflict, if there is an international armed conflict, then international humanitarian law applies. Not because there has been a referral by the Security Council, but because that is what is in the Geneva Convention.
No, sorry, Manjo, just to be clear on that point. Sorry, what I'm saying, and perhaps I didn't say that quite, didn't articulate that quite clearly. What I was referring to is the prosecution of war crimes by the ICC.
That's
sorry,
right.
and
So this time I'm actually focusing on, because, okay, hang on. Is the torture of prisoners of war a war crime?
Yes.
Is it in the Rome Statute?
Well, so Syria is not bound by the Rome Statute. That's my point.
So that's the first problem we have. In fact, the definition of who is a prisoner of war is based on the Geneva Convention. Unfortunately, according to the Geneva Convention, you can only invoke the Geneva Convention if it is an international armed conflict, which actually leads to the question of, does international humanitarian law apply in the case of Syria? Now, and this was the point I was raising earlier with that group. There are there are three kinds of armed conflicts. You have the international armed conflict, and that is an armed conflict between two states. And only if there is an armed conflict between two states can you invoke the concept of prisoners of war. Are we clear? So in other words, if there is no war between Syria and say US or Syria and Russia, there is international humanitarian law in that sense is not applicable. So there is no concept of prisoner of war. If you go back to the history of the Geneva Conventions, the reason why they had a separate category known as non-international armed conflict was that the United Kingdom, for example, was dealing with the Protestant rebel groups within the UK itself. And it did not wish for international humanitarian law principles or the laws of war to apply in relation to the internal disturbances within the UK. So in other words, states at the time that the Geneva Conventions were drafted and created were aware that they purposely limited to the application of the laws of war or the international humanitarian law to the international armed conflict or armed conflict between states. Now, there's another category known as the non-international armed conflict, and that is any armed conflict that does not involve states. So in particular, that has been that can involve an armed conflict between a state and a rebel group, which is organized and it controls a part of a territory of a state. So potentially, in this case, in the war of Syria, the international humanitarian law can be applied, but only an aspect of international humanitarian law, and that is the treatment of civilians and those who have been captured in the course of that armed conflict. But the other Geneva Conventions actually do not apply. So,
right. Yep. No, I agree with you. I just had a question.
Yes.
So just on the issue of chemical and bacteriological weapons,
Mm-hmm.
so some of the treaties and conventions Syria is bound by. So they've signed those treaties. Some they are not. So I guess it would be a matter of going through the treaties and conventions and determining which ones Syria has signed, which ones they are bound by, and sort of trailing through it. And determining, okay, so they've signed the Biological Weapons Convention, they haven't signed, or they ratified this document, but they haven't signed this. I totally understand what you're saying, and I think it's very relevant.
Yeah, I'm sorry, I'm going to go back to that, but I wanted the class to really understand this idea that if international humanitarian law doesn't apply in general, meaning, so if there is no international armed conflict, because it is not an armed conflict between two states or between several states, then a lot of the Geneva Conventions are not applicable. For example, pertaining to the prisoners of war, pertaining, for example, to interning those who are captured, pertaining to protection of civilians. A lot of these are not applicable because these Geneva Conventions, which comprise broadly the notion of international humanitarian law, is generally applicable only in relation to international international armed conflict, which, as defined in the Geneva Convention, is actually an armed conflict between states. Now, if what we have is a non-international armed conflict, then there is a provision in the Geneva Conventions where there is protection of civilians and those who are captured, but that is actually just one singular provision in the Geneva Convention itself. So you have to be careful about this. Now, which brings us, therefore, to that question that if a state bombs its own citizens, such as what Bashar al-Assad is doing, the question is, can international humanitarian law be invoked? So if you have a repressive regime, such as Bashar al-Assad, and it is bombing its own civilians because it's trying to attack, destroy the rebels, the question is, does general international humanitarian law apply? And the answer likely is not most of the 4 Geneva Conventions will not apply. So you just have to be very careful about that. Now, having said that, in addition, you have to yes.
Yes, no, whenever you're ready, I just had a
the other point is, if there is a breach of international humanitarian law, it doesn't mean that because there's a breach of international humanitarian law, there is therefore a war crime that has been committed. They're two different things. So war crimes will generally be defined by the Rome Statute and also as defined by customary international law, especially because we have a definition of war crimes and, for example, genocide on the basis of what transpired during World War II. Okay, but the mere breach of principles of international law is not similar to the commission of war crimes. So you just have to be very careful about that. Now, the other point, which of course you're not really addressing here, which is really isn't necessary, is really the notion of international human rights law. And so the bombing, for example, the torture of prisoners of war, so-called prisoners of war, because they're not really prisoners of war. So those who are captured are really not prisoners of war. And the reason why they're not considered prisoners of war is that, again, historically, as I pointed out, if a person is a prisoner of war, then that person is not subject to the domestic jurisdiction of court. So they cannot be charged with murder, with rape, and so on, because they're treated as prisoners of war. They can only be tried under the laws of war. But so, in other words, if a person is a prisoner of war, you apply the law of war, or international humanitarian law. On the other hand, if somebody who is captured, let's say part of a rebel group, is captured, that person who is captured is not considered a prisoner of war under international humanitarian law and could actually therefore be prosecuted under the domestic laws of the state. So Syria can prosecute the rebels in Syria who have been captured because they cannot be treated as prisoners of war because international humanitarian law generally doesn't apply, because this is not a war between states. So you have to be very careful about torture of prisoners of war because that is not happening. There is a distinct meaning to of the concept of prisoners of war in international humanitarian law. So the rebels who are captured in Syria, they cannot be treated as prisoners of war. They are treated as common criminals. Now, when common criminals are tortured, such as, for example, when the US tortures Al-Qaeda terrorists or ISIL terrorists or ISIS terrorists, the question is the US torturing prisoners of war? The answer is no. Because, as you will know, these terrorists are not even covered by the notion of international armed conflict. They're not covered by the notion of non-international armed conflict. They are covered by other armed conflicts which are not international and which are non-international, and in which case, therefore, they are not covered by the principles of international humanitarian law. And so, therefore, when the US tortures these terrorists, you cannot say that the US is violating international humanitarian law. When Bashar al-Assad captures and tortures these, okay, I'm speaking from a legal viewpoint, nothing moralistic about this, okay? So I'm speaking as a lawyer, not as a, it has nothing to do with my feelings. I'm just stating the law. So when Bashar al-Assad tortures the rebels who he captures, when Syria shoots and kills the rebels it has captured, it is likely not committing a breach of international humanitarian law because it does not apply. Because these rebels cannot be treated as prisoners of war. They can be treated by Syria as common criminals. And if Syria therefore treats them as common criminals, these common criminals are subject to the laws of the state of Syria. And remember, because of the notion of territorial sovereignty, it is up to each state to determine its own laws, and it cannot be subject to the control of any other state. So if Syria decides that somebody who engages in rebellion should be shot on sight, that will be legal from the viewpoint of international law. So I'm just flagging that to you because I want you to avoid simplistically labeling what's going on in Syria as a violation of international humanitarian law. So that's the problem, therefore. If somebody is captured, let's say a rebel, and that person is not considered a prisoner of war because there is no international armed conflict, that person is subject to the internal laws of a state and will be treated as a common criminal. So if a state says that the death penalty, shooting on sight, hanging, whatever firing squad is legal on site and on the spot, the international community cannot intervene because of the principle of territorial sovereignty. Okay, so having said that, it's now 8:24. We're going beyond our time. So as I said, I've given a rating to the group of Marquesa, 23 out of 25 for organization, 20 for content, 22 for presentation, and in relation to responses, 20 out of 25, which again is a high distinction. Is it? It's 85 out of, I don't know if it's a high, so that's probably a distinction. So you're getting 85 out of 100. So having said that, take my comments into account when you work on the individual research essay. Any comments or questions before we end tonight's session?
Yes, Manjo, I just have one question. Yep,
Go ahead.
sorry. So just on the issue of going back to the issue of war crimes and chemical and biological weapons. So when we just use the word international humanitarian law, are we just creating not just the treaties, the conventions, or are we saying, no, examine each treaty individually? And if Syria has signed the treaty in which case they have for the biological and chemical weapons, then indeed they have committed a war crime and can be prosecuted under that treaty, as opposed to where the complexity is and the I did say confusion, but where the complexity arises is when it's referred by the National United Nations Security Council, because at that time the ICC are adopting a lot of the verbiage from the convention. So you're in a sense, they're in a sense prosecuting.
Okay, Marquesa, can I just stop you there because you're speaking of a lot of concepts and we might get lost. And I'm trying to follow what you just said. So the first point was there are conventions concerning the use of biological weapons and chemical weapons and so on, of which Syria might or might not be a party. In that case, if Syria is in fact a party and it breaches a convention, then there is a breach of international law, a breach of conventional international law.
Okay.
Okay. Now, the breach of that convention will not necessarily mean that there has been a commission of a war crime, because a war crime is as defined by the Rome Statute. And for the Rome Statute to be applicable, then a state must be a party to the Rome Statute. And as pointed out by the first group, Syria does not seem to be a signatory to the Rome Statute. Now,
Correct.
there is a general conception of what a war crime is because of what happened in World War II. But it is easier to prosecute now potential war criminals on the basis of the Rome Statute. But the main criterion there is that a state must have been, a state of which a person is an officer and committed war crimes, must be a party to the Rome Statute. So let's just clarify that. Okay, so the mere breach of a convention such as a biological weapon does not mean that there is a war crime. Potentially, there might be a commission of genocide, which is different because that is based on a peremptory norm of international law. So when you kill hundreds and thousands of people by using chemical weapons, potentially you might be committing genocide. Potentially, I don't really know. Okay, I'm making that statement. Now, what was the other point there that you mentioned?
Just about the referral from the United Nations Security Council to the ICC.
Yeah.
That with the jurisdiction. And so my question was in relation to the convention, because if they're not party to the convention, they're not bound by the convention, but yet they're bound by, if they are prosecuted by the ICC as a result of the United Nations making that referral, then they are in a sense bound by the convention because the ICC statute is almost, I don't want to say very similar to, but almost identical to the Geneva. So that's why it's a bit, it's
No, they're not similar.
Some of the provisions in the ICC statute are very similar to the Geneva Convention.
Okay, there are at least 4 main Geneva Conventions as far back as 1829. And the discussion there is not about war crimes, actually. It's more about how to deal with instances of armed conflict, whether in relation to civilians, those who are wounded, those who are captured, and so on. The Rome Statute pertains particular to the war crimes. Let's just clarify that. Before I forget, the problem really now with the press is that there is a reference to what is known as an international humanitarian crisis, which is really true. What is happening in Syria evokes notions of an international humanitarian crisis. But the mere fact that there is an international humanitarian crisis does not mean that there is an application as well of international humanitarian law. They're 2 different things. Okay, so international humanitarian law, which is actually also known as the law of war, will only arise if there is an armed conflict between states, or an armed conflict in a what is known as a non-international armed conflict, only in the situation where there is a conflict between a state and an internal rebel group, for example, that is highly organized, that is in control of a part of the territory, and that is willing to abide by the laws of war or international humanitarian law. Okay, I think we've gone much beyond the time limit. Any other questions before we end tonight's session? So the 2 groups did really well. Was it just 2 groups? It was 2 groups, right? Okay, getting confused. I had another tutorial earlier. So the 2 groups did really well, and I'm looking forward to the future presentations from the other groups. Now, before we end tonight's session, are there any questions or comments you'd like to make? None? Okay, then.
I just want to thank you for clarifying that point, Manjo. It's clearer to me now about war crimes and a state matter that's not involving another state. So yeah, it's a bit clearer to me now. Thank you.
Especially in relation to the individual research essay, which comprises 50% of your grade. So you have to be very careful about what you state there. Okay, at least I flagged that to your attention. And just make sure you focus on 1 or 2 fundamental issues. Don't cover everything. It's not possible. Okay? Okay, so thank you to the 2 groups. You both did really well. And thanks for joining tonight's session. And I'll see you again next week. Good night. Bye.
Thanks so much. Bye.
Bye.